So the second one ties into that quite nicely. So there might be some repetition because we break these videos up into smaller portions for our viewers on YouTube. There might be some repetition, but it does go in a different direction. So from Annika, she asks, how do we deal with latent defects? The seller's declaration that it is that's attached to the OTP states that he was not aware of any defects that are known to him. Please help.
Perfect. Yeah. So the trick with this really comes down to the knowledge of the seller in the circumstances. All right. So latent defect, the very fact that we're talking about a latent defect means that it is something that is outside of the knowledge of the seller in the circumstances. So when the declaration says there, well, I'm not aware of any defects on the particular property, the assumption is, well, they weren't aware of it. Okay. And that's the position that we go from. Now, latent defects generally, unless we're falling under a circumstance where the Consumer Protection Act does apply, and relates to the particular transaction. And now remember, that doesn't relate to individual sales. People who are selling their houses from one person to another. Generally, your Consumer Protection Act is not going to come into play at that stage. It's only going to come into play where there's a certain commercial transaction which is occurring. So your individuals who are selling houses as a business in the circumstances, then your Consumer Protection Act is going to come in and have different provisions with how that transaction works. But in your normal, I'm selling my house to someone else who's going to use this place as their house, after the sale, Consumer Protection Act is not going to come in. So you're going to have things like footstood clauses which kick in on that particular transaction, and they will actually be enforceable because they fall outside of the ambit of the Consumer Protection Act. So the trick when it comes to the latent defects, these are naturally things that your seller might not know of, weren't aware of. And in those particular circumstances, the latent defects are what they are. Unfortunately, you can't void an entire sale in the circumstances for something that was out of the knowledge of the seller in a particular transaction. Where this changes is where there are defects which are material and were to the knowledge of the seller in a particular circumstance. Okay, and especially in circumstances now where we've got the seller's declaration, the seller is saying, well, I'm not aware of any particular defects on the particular property. But if it can be shown that it was in fact within their knowledge, okay, there is an element there where they are, either trying to misrepresent this, and to the point where it might actually be a fraudulent misrepresentation. And in circumstances where you can establish that there's a fraudulent misrepresentation, there may be an ability to set the sale aside. However, although that's how it would work in theory, the practice from a legal perspective is a very, very difficult question, because the question is, how do you show the intention of the seller in a particular circumstance? How do you demonstrate that it was their intent to fraudulently misrepresent the position on the particular property? And there are ways of doing it. It's not an impossible task, but it's certainly a hard call for lawyers, because to demonstrate the intention of who would be the other litigating party in the circumstances may be a massive challenge in the circumstances. And certainly you wouldn't want to engage on that particular line of questioning unless it was something very material and something you've got substantive evidence to demonstrate, well, they clearly intended to defraud me in the circumstances or misrepresent in the circumstances what the defect was. In those circumstances, yes, then the seller's declaration is going to be a part of the plethora of evidence you'd use in the circumstances to demonstrate that they intended to misrepresent the true nature of the property. But certainly, I wouldn't lay all my eggs in a basket to say, well, there's a seller's declaration that the property does have a defect and he didn't know about it. I think that you'd need some ancillary evidence on top of that to demonstrate that there was intent to misrepresent in the circumstances. I don't think the seller's declaration would get you all the way there.
Absolutely. Do you want to touch on maybe the declaration itself and how estate agents fit into that? Like, just briefly?
Yeah, so we've got to remember now the declaration is part part and parcel of what now agents have to do in the circumstances, and it's got to be attached to the agreements. So it's a really important document, and we've across the industry we've been touching on this, and the need to have the seller's declaration attached to OTPs in the circumstances. Remember, there are consequences as a result of not having attached the declaration to the OTP. For the agent specifically in the circumstances. So it's got to be attached, guys. It's a simple document. I know a lot of our agencies, we've been talking to agencies and they're saying, well, what do we do with this particular document? The document itself isn't something complex. The consequences as a result of not using the document are complex. It's a mere declaration. It's a simple document in circumstances, but it's important to get it right, to attach it to your documentation in the circumstances.
Agreed. Cool. Thanks so much, Nick. That's very well answered. So I suppose that's both questions.
Yeah.
I hope the viewers got value out of it, and thanks again for joining us.
Perfect. Thanks for having me.
Awesome. Great. Thanks. Cheers, everyone.